8:15 to watch the trial. And until then, you can enjoy some of the events down here. Thank you for coming.
You've all heard of double jeopardy, right? And I'm not talking about the second round of the largest running game show in TV history. You've all heard of the Fifth Amendment, which protects you from self-incrimination. And while we're talking about TV, how many times have you heard a criminal plead the fifth on some crime show? Hundreds, right? And how many times have you heard the authorities tell the individual who has just been arrested they have the right to remain silent, that anything they say may be used in court? Well, those are your Miranda rights. But it's 1917, and we're 50 years away from those rights, coming into law as dictated by the U.S. Supreme Court. And then law enforcement saw no reason to inform criminals of their rights, or offer them a crash course in constitutional law, and especially if you're a foreigner. However, our forefathers had the foresight to include a clause in that Fifth Amendment intended to protect citizens from what so many were experiencing at the hands of British law prior to the Revolution. Nor shall any person be subject for the same offense to be twice put in jeopardy for life and limb. And our forefathers felt that one need not know the law to be protected from it. Thus, a Russian like Nick Kamanos, although not a U.S. citizen, was still protected by the laws of the country if he was residing. You see, Nick Kamanos had already been acquitted of killing Daniel McLean on May 14, 1917, during that bank robbery. And now, days later, he was on trial for the murder of Frank Irving. Kamanos had been hired by Mikhail Titov, the ringleader of the bank robbery. Or more specifically, Kamanos' 1916 touring car had been hired. Kamanos, who demanded $7 payment in advance, was told he was driving Titov to a mine on the south side to seek work. When Titov showed up with 3 others, Kamanos said nothing. And when those 4 stopped off at a saloon early on in the drive, Kamanos may have thought his actual job was to cart around men who fight to get drunk. So you see, even 100 years ago, we still had designated drivers. Or so Nick Kamanos thought. Hear ye, hear ye. The Court of Allegheny County is now in session. The Commonwealth of Pennsylvania versus Nick Kamanos on a charge of murder in the first degree. The Honorable James R. McFarland presiding. All rise.
Be seated. Gentlemen, present yourselves.
Harry R. Rowland, Your Honor, for the Commonwealth.
A.C. Kramer, Your Honor, for the defense. Your Honor, I submit to the court that all charges in this case be dismissed on the grounds of double jeopardy.
Your Honor, objection, immaterial and irrelevant.
The fact that my client was acquitted of one murder is far from irrelevant. Your Honor, in fact, it is quite clear in the Constitution that no man...
Mr. Kramer, we spoke of this in pretrial hearing. Your motion is denied.
Objection, Your Honor. This case has been compromised by Mr. Kramer's outburst. I ask that the jury be excused before to continue this matter.
As we should. Continue, I mean. But we should continue. Mr. Camanos has been acquitted of murder already in this case.
Mr. Kramer, sit down. We have already discussed this. Your dismissal is denied. Mr. Rowan, your objection is overruled. Both of you sit down and listen. Gentlemen of the jury, as this issue has been broached, I believe it right for the court to explain itself. Mr. Kramer claims under Article 1, Section 5 of the U.S. Constitution that Mr. Camanos may not be tried for murder again based on the fact that he was earlier acquitted of the murder of Daniel McLean, a teller in the bank, and thus could not be tried for the murder of Frank Irby, the second teller murder in this single incident, a robbery of the bank in Castle Shannon, as that would be double jeopardy. Counsel for the defendant contends that the fact was one and the same robbery, and the perpetuation of both men were killed required the court to instruct your members of the jury to render a verdict in favor of the defendant. However, the act of April 22nd, 1794, found the murder perpetrated in the commission of robbery is murder in the first degree. By the common law, where a murder was committed by a body of men engaged in robbery, the act of killing is treated as if specifically committed by each individual. Each is responsible for such collateral acts growing out of the general design as may be committed by his associates, and each may be tried for each murder. In this case, there were two independent homicides resulting from the two malicious shootings. The defendant, in the former trial, could not be found guilty of the murder of Irby, and he was not acquitted of that offense, nor was he in jeopardy. The defendant was tried and acquitted of the murder of Daniel H.A. McLean, the cashier of the Castle Shannon Bank, during the perpetration of a robbery of the bank in which Frank W. Irby, assistant cashier of the bank, was killed at the same time. Gentlemen of the jury, the main question are these. Was Mr. Camanos in the bank? If not, did he have knowledge of the purpose of these men, and was he aiding and abetting them? That, in summary, is the standing of the court. Mr. Kramer, your motion to dismiss is denied. Mr. Rowan, call your first witness.
I call Harry B. Cochran. Mr. Cochran, state your occupation.
I'm assistant detective in Allegheny County.
And how long have you served in that capacity?
7 years now.
Were you so employed on May 14, 1917?
Yes, sir.
Were you called to Castle Shannon on hearing of trouble there?
Yes.
Did you see the defendant there at that time?
Yes. A short time after I got there, they brought him in.
And did you take charge of him?
Yes, sir, and we brought him to the courthouse.
Did you have a conversation with him at that time with reference to this case?
Yes, sir.
Would you give us that conversation as you remember it?
Well, I asked him if there were any person with him, and he said no. That he'd left Universal that morning and he couldn't recollect the name of the man who came in with him as far as East Liberty. But the man got out of the car. He said he drove from the bridge out into the country and was driving until he was overtaken by the men in the machine.
What men?
The men from Castle Shannon who went out to get him.
What else did he tell you?
He said there was nobody in the vehicle after the fellow got out at East Liberty. From that time till he was taken out of the machine by those men on the road.
No further questions, Your Honor.
Your witness, Mr. Kramer.
When did you pick up Mr. Camanos to take back to the courthouse?
About 3 o'clock or so.
What was his physical condition at the time?
His face was all swollen.
All beaten up, wasn't it?
Yes, sir.
If your officers hadn't arrived up there, the crowd would have lynched him, wouldn't they?
Objection, material and irrelevant.
Objection sustained.
Did you hear the time was being beaten up out there in Castle Shannon? Did you hear anyone make a suggestion of lynching?
Objection, this is not cross-examination and it's immaterial.
Sustained. Mr. Kramer, you are hereby warned that should you persist in this questioning, you will be held in contempt of court.
No further questions, Your Honor.
Rebuttal, Your Honor.
Allowed?
Mr. Cochran, you showed Mr. Camanos photos of the men involved in the robbery, did you not?
Yes, we did.
Did he identify any of them?
He said one of them was the man who'd been shot through the head, Sam Barkins. He said that was the man who rode out as far as East Liberty with him and got out.
Did he see any others?
He said he'd seen another, a Michael Tito, at a christening about 6 months ago. He said he hadn't seen Barkins, in 6 months either.
Thank you, Mr. Cochran. No further questions.
Permission to cross-examine here.
Allowed.
Were you a witness in the previous trial of the same defendant?
Yes, sir.
You testified nothing of that kind in the previous trial, did you?
Objection, immaterial.
Sustained.
I called for an exception.
Duly noted, exception allowed, and bill sealed. Mr. Rowand, your next witness.
I call Stanley Rowell. Mr. Rowell, where do you work?
The South Hills Building Supply in Castle Shannon.
Do you know the location of the First National Bank there?
Yes, I have a deposit there.
Did you know Mr. Irby, Frank Irby, the assistant cashier?
Yes.
Did you have occasion to visit the bank on May 14, 1917?
Yes, I went in about 12:30.
Tell the jury what you did when you entered the bank.
Well, I came in here with a $100 check to deposit, and I went to Mr. McLean, and he gave me a slip. About the same time, about 6 men came in the bank and stood around me and started shooting. They didn't say nothing, they just started shooting. I was scared, and I backed towards the door, and one of them said, stay here and put your hands up. He pushed me into the left corner. He said, stay here in about half an hour. When we're done, we'll let you go.
Objection. Unless this is to be followed up by evidence that all this was said in the presence of the defendant, we object to it and move that it be stricken from the record.
It certainly will be followed up, if Your Honor pleases, by other evidence connecting this defendant with this robbery and his coming out of the bank immediately after the shooting.
Continue, Mr. Rowand.
Thank you, Your Honor. What happened next?
He took a handkerchief and put it over my eyes because I started to look at what they were doing. Don't look them fellas, I shoot you, he said. I turned my head against the wall. He took a rope from his pocket and tied my hands. Then the handkerchief fell off my eyes. Then they ran out of the bank.
How many men were in the bank?
I think there were 5 or 6.
Objection. The question was how many men were in the bank, not how many men he thought you saw.
Sustained. Rephrase your question, Mr. Rowand.
So you saw them as they went out?
I heard one of them say, run away in Russian.
You understand the Russian language?
Yes, sir.
Did you know any of these men?
No, sir, I never saw him before.
After they left, did you see Mr. Irby?
I went into the cage and Mr. Irby's head was under the counter. He was dying.
Did you see, excuse me, the man who pointed the gun at you, what was he wearing?
Brown, he had brown hair, I think, because,
Excuse me, well, what was he wearing?
oh, he was wearing a grayish coat.
And what color was his shirt?
He had on a blue shirt.
Now, what color was his hair?
It was brown, I believe because he had a cap on. He had a dark cap on.
Mr. Rowell, is the defendant the man you saw in the bank with the cap on?
I can't tell you that.
What?
I'm not sure. I think he was in the bank, but I'm not sure.
Objection. I move that the court strike out from the record the part of the answer, I think he was in the bank. As the witness says he cannot tell, I object as to it being unfair.
Motion to strike refused.
Your witness, Mr. Kramer.
Mr. Robb, were you tied in a position where you could see the men that were in the bank and what they were doing?
Certainly.
And still, you don't know whether there were 5 or whether there were 6.
Well, I think...
I didn't ask what you think. What did you see? Were there 5 or 6 men?
I said it wasn't less than 6.
It wasn't less than 6.
Yes, sir.
So you're sure there were 6 men there?
Well, not less than 6.
Well, now, there may have been more than 6.
Not more than 6. I'm sure it was 6.
Well, in other words...
Objection, Your Honor. Counsel for the defense is badgering the witness.
No, Mr. Rowe. Counsel for the defense is just trying to get the facts. Were there 6 robbers, 5 robbers, 7 robbers, or were there a dozen robbers? This man witnessed the crime incident and clearly said he looked at the robbers, despite being told not to do so. And I'd just like to determine if he saw 5 robbers, 6 robbers, 100.
Your Honor, counsel is using sarcasm to summarize his closing argument.
Gentlemen, both of you sit down. Mr. Rowand, your objection is overruled. Proceed, Mr. Kramer.
Now I have the last question read back.
Kramer, well, Now, there may have been more than 6. Wow. More than 6. It was 5. I can't tell you.
So, you are sure there were 6 men there?
Well, it was less than 6. I'm sure it was 6.
In other words, you're not sure whether there were 6 men or there were 5 men, are you?
Well, at the time, I think,
I'm not asking what you think. Are you sure there were 5 or 6, or don't you know whether it was 5 or 6?
not less than 6.
There might have been 7 then.
No, sir.
Do you know, sir, positively, there were just 6 men there? Do you know for a positive fact there were 6 men?
I think it was 6.
But you are not sure, Mr. Rallah, are you?
Well, I can't tell you.
You can't tell for sure.
No, sir.
And you can't tell for sure what they wore and the color of their clothes, can you?
Sure, I can tell because I was looking at it.
All right, some of them wore gray suits.
Oh, they have black suits. Most of them have black suits.
Well, how many had black suits and how many had gray suits?
I can't tell you.
You can't tell that either.
Because I can't count them.
Could you recognize the men that were in the bank?
Well, I recognize one.
One.
Because he held a revolver in my head for 10 minutes so I could recognize him.
You were looking at him for all the 10 minutes you were in there, were you?
Yes, sir.
Well, you didn't have much chance to look at the other men?
I told you, he said, if you look at those other men, look at them, I'll shoot you.
So you didn't look at them,
I looked anyway.
and you recognized one of them.
Yes, sir.
The man who held the revolver to your head.
Yes, sir.
And you can't swear to any of the others.
No, sir.
So you don't know whether Sam Barkins, the man you saw in the hospital, was in the bank or not.
I'm sure he was.
Then you recognize 2 of them, not 1.
Yes, sir.
Do you know whether this man was in the bank?
I can't tell you that.
Mr. Robb, you were a witness at the coroner's hearing, were you not, on June 19th?
I think so.
And you were sworn and testified there, didn't you?
I think so.
And you were asked if this was one of the
Now,
people
wait.
that was
I will ask you to read the question and answer to the witness.
at the time. You were sworn in as a witness in the inquest down there. This man was down in the morgue building, wasn't he?
I don't remember whether I was there or not.
You don't remember whether you were there or not. And don't you remember that you were a witness and sworn there? And don't remember if this man was present?
I don't remember that.
You don't remember that.
No, sir.
Do you remember when Sam Barton's case came up in this court on the 11th day of December 1917?
Yes, sir.
And didn't you say at that trial that you couldn't identify any of the men at the bank?
Give objection unless the question and the answer read to the witness that was put to him and answered at that time.
I have the evidence in Barton's case. Mr. Robb, weren't you called as a witness and testified on Thursday, December 13th, at the trial of this man here?
Yes, sir.
And weren't you asked the following question? Question. You testified here in this case on Monday, didn't you? Answer. Yes, sir. Question. And didn't you in your testimony say you could not identify any of them? Answer. Well. Question. Didn't you say that on Monday? Answer. Yes, sir, I did. Do you remember giving that testimony in this man's trial on Thursday, December 13th?
I might.
Well, you admitted then that you couldn't identify any of the men in the bank. You stated that, didn't you?
As I get the construction you put on it, you say, quote, didn't you admit that you had testified at some other time and thus and so, unquote. But that is not an admission that he could not identify them. That is an admission that he stated that at the trial.
On another trial under oath in the case of Sam Bartels.
That was not an admission in the trial of December 13th, 1917.
But in this man's case, Thursday,
But that is what you are claiming to read to him.
his admission that he had previously made on that day that he could not identify anybody.
And the question is not strictly correct.
But as affecting this man's credibility.
He did not admit anything of the kind. He admitted that he made the statement at the other trial. If you want to get to that, if you want to get that out of him, you should put it into him straight, Mr. Kramer.
So today, you said that you can identify two men. The man who rolled the gun on you and the one who's in the hospital.
Yes, sir.
Didn't you, on Tuesday, December the 11th, state under oath that you couldn't identify any of the men?
I object to the form of the question unless counsel produces the record.
I will produce the record tomorrow here. I cannot do it this evening.
You can ask him without the record. The record is not the only evidence.
That was in Sam Barton's trial. Didn't you so testify?
I don't remember whether I said that.
Your memory isn't so good, is it, Mr. Robb?
No, sir.
You were pretty much excited when the shooting was going on.
Certainly.
And nervous. And you can't undertake to say the things that transpired there, can you? No further questions, Your Honor.
I call George Beltsuber to the stand. Mr. Beltsuber, do you hold any official title?
Justice of the peace.
Do you remember where you were around noon on May 14, 1917?
I was at my house having lunch.
Did you visit the bank around noon that day?
I left the house around 12:15 to go back to my office. I had a couple of hearings at 1 o'clock, but I didn't get to my office.
Why not?
Mrs. Harry Chandler came out on the street and says, "My God, George, come quick. They're robbing the bank."
What did you do?
I went up to the bank.
Tell the court what you saw.
Well, when I got to the bank, I went up and I looked through the door and I saw some men running out of that little door to the right of the bank, and they were shooting what sounded to me like a shooting gallery. After I looked in, I stepped back towards the bushes.
Did you see the men come out of the bank?
Well, one man came out and then two came together.
Can you identify any of those men here?
Right there's the first man who came out of the bank.
Do you mean the defendant sitting there?
That man sitting at the table.
How was he dressed that day?
He had a dark suit on and a slouch hat.
Anything in his hand?
He was carrying a pistol.
What did you do then?
Well, I had grabbed a shotgun from somebody. So I stood my ground and I aimed it at them. "Stop right there, you sons of bitches!" Well, when I fired my shotgun, it was empty. Now, the two fellows who came out together leveled their guns at me. Now, I stayed as long as I could, but it got a little too hot and I left. As I went around the corner, I don't know what happened. To be candid about it, when I came to, my nose was bleeding and I had a bump on the back of my head.
And when you came to, Squire, where did you go?
I went to my mother's store. I grabbed my shotgun and I went to the streetcar tracks and I hollered for someone to bring an automobile. Now, Edward Laughlin, the undertaker, he brought one. So I got in the machine and the boys say, "Well, what do we do if we run on them?" And I says, "Shoot. Shoot to kill."
Where did you go then?
Well, we went to Mount Lebanon. Now, one lady, I don't know her name, she says a machine went by in the other direction with 3 or 4 men in it. "We'll go that way," I says. So I asked the Bell telephone man, now he was repairing the line, if he had seen anyone. He says, "Yes, a man was going through and wringing his hands."
Ask what these men said to this witness. I object to this hearsay. Ask them to be stricken.
Motion allowed.
Tell what you did, Squire, without telling what people told you as you went along the road.
Well, we went to Mount Lebanon and then we doubled back to Castle Shannon.
Did you find anybody?
We did not.
When did you next see the defendant?
In my mother-in-law's front room in the parlor of the house on Willow Avenue.
How was he dressed?
In a dark suit with a slouch hat.
No further questions, Your Honor.
Permission to cross-examine, Your Honor.
Allowed.
Mr. Beltsuber, when you looked at the bank, what did you see?
I saw 3 or 4 men coming out of the side door, the little door in the side room. It leads into that little room and then into the cage in the bank proper.
When you stood outside the bank, how many men did you see come out of the front door? Did the 3 come out together?
Yes, sir.
Did you see any others come out?
No, it got too warm and I went to the back end of the bank.
If you didn't see them come out, you don't know how many were there.
I told you there was 3 come out of the bank.
3 was all you saw.
Yes, sir.
Do you know those 3 men?
No, but I recognize him. There was the man who killed himself, the man that we found in the woods near the golf course, and this man here.
They rushed out right toward you.
Oh, they went right on through. They turned to the left and went up the alley.
Well, who came out first?
That man right there.
And you ran to the rear, ran into the men there.
I didn't say that. They ran past me and I got struck.
There was a lot of confusion, wasn't there? You were excited, weren't you, Squire?
Well, I'd rather think I was.
And there was a lot of confusion there.
Most undoubtedly there was.
And there's no possible chance of being mistaken about your seeing this defendant come out.
If there was any doubt, sir, I wouldn't get up and swear to it.
Mr. Kramer, further questions?
Not at this time. However, I reserve the right to recall this witness.
Prosecutor Drummond called 20 witnesses to testify. 3 of the most damning were Nicholas Yost, A.L. Austin, and Charles Berger. Yost testified that he was shot in the shin by Camanos, who was firing back at him while seated on the driver's side of the vehicle. Austin, a justice of the peace in North Bessemer, testified that Camanos registered his 1916 touring car with him, as per state law, under an assumed name. And Berger, a bartender in the Keys Hotel, testified Camanos was in his bar the Saturday before the robbery with Sam Barkins, the bank robber who unsuccessfully tried to commit suicide by shooting himself.
Is the defense ready?
Yes, sir.
Defense attorney A.L. Kramer called 17 witnesses, almost half of whom testified to Camanos' reputation in the community. But the 2 primary witnesses were Sam Barkins and the defendant. Barkins, who had tried to commit suicide by shooting himself through the roof of his mouth, had pled guilty and had been sentenced to death by electrocution.
I call Sam Barkins. Mr. Barkins, you were one of the defendants in this case, were you not?
Yes, sir.
And you pleaded guilty, generally to the charges.
Yes, sir.
Do you know Nick Camanos?
No, sir, I don't know him.
Did you know Mike Teton?
Yes, for about 6 years.
Did you know Harasco Garrison?
I boarded with him on Fifth Avenue.
Do you know John Tush?
Yes, he boarded with Mike.
Do you remember seeing this man, Nick Camanos, on May 14th of last year?
Yes, sir. I saw him when he came with his automobile. I saw him that day.
Who was in the automobile with him?
Mike was sitting with them.
Mike Teton, you mean?
Yes, sir.
You were standing on the street with Tush and Harasco when you saw him, correct?
Yes, and Mike says, come on in the automobile with us.
And then where did you drive to?
To the south side.
And did you go to any place on the south side where the machine made a stop?
Yes, sir. Mike said, stop here at the saloon on south side.
And then what did any of you do when you got to the saloon?
It was Mike's birthday. He was treating us to drinks.
Who do you mean by all of you?
Harasco, myself, and Tush.
Did Camanos go into the saloon?
No, sir.
How long were you in the saloon?
For about 20, 25 minutes.
Did Teton tell you anything in the saloon?
No, sir. He told us not to talk in the machine.
When you came out of the saloon, where did you go?
We went a ways along the street. I don't know for how long. I went to sleep. Mike told me, wake up, wake up. What are you sleeping for?
When the machine came to the stop, did you all get out?
Tito, myself, Harasco, and Tush got out.
Did Nick Camanos get out?
Oh, no, he stayed in the machine.
While in the machine, did any of you talk about anything?
No, sir. Mike told us not to talk.
When you got out of the vehicle, where did you go?
Mike told us to come with him. We walked for about 5 minutes or so, and Mike says, do you know where we're going? We're going to rob a bank and get money. And he gave me a revolver and a little 2 ropes.
Now, you all did go in the bank, right?
Yes, Mike went in first. We were all 3 or 4 steps behind him.
Was Mr. Camanos in the bank?
No, sir, he was not. It was just the 4 of us.
So Mr. Camanos did not go into the bank?
No, sir, it was just Tito, Tush, myself, and Harasco.
What happened in the bank?
Well, Mike went to the teller window and said he need change for a 10. Then he told them to raise their hands. And when they did not raise, he began to shoot.
There were a lot of shots, were there not?
I could not say. There were a good many shots.
Then what happened?
We ran out of the bank. Tush and me were the first out.
Did you carry anything out of the bank at all besides guns?
I didn't know whether he did or not, Tush.
And where did you go when you ran out of the bank?
We went through the alley, climbed over a fence, and ran down the street. We were running towards the woods.
Did you get to the woods, you and Tush?
No. Tush killed himself in the field. I turned around to get his revolver. I had lost mine somewhere. Maybe climbing over the fence.
You didn't take any bag, he had?
No, sir, I had the money.
Oh, you had the money yourself. That was in a bag, was it?
Yes, sir. I ran. I was intoxicated and went to sleep in the woods.
What was the next you know of?
Well, I was asleep, and someone shot me.
Where were you shot?
Through the mouth and
out through the head.
Out through the head. Right here.
You were taken to Southside Hospital.
Yes, sir.
Do you know what direction T-Top and Carrasco ran?
Oh, no, sir.
Was there anyone else running with you and Tush?
No, sir, no one.
Nick Kamanos was not with you?
No, sir. Just Tush and myself. And there were about 4 people chasing us.
Had you made any arrangement with the defendant, Kamanos, to rob the bank that day?
No, sir. We talked nothing about it.
Did you know of any arrangement with any of the 4 men who went into the bank and made with Kamanos about robbing that bank that day?
That's objected to, Your Honor. Hearsay.
Objection sustained.
Did you hear any arrangement made by anybody with Kamanos to rob the bank that day?
No, sir.
Your witness, Mr. Allen.
Mr. Barkins, where do you work?
I work at the cement works in Universal.
The same cement works where Nick Kamanos, the defendant, works?
He was a Lodi.
You knew him?
We were in the same works, but not in the same area.
On Saturday, did you drink with Carrasco and T-Top?
No, sir. I was drinking with them in the speakeasy on Sunday.
But not on Saturday? Did you know if anyone was drinking with Nick Kamanos on Saturday?
Objection, Your Honor. Mr. Barkins indicated he was not drinking in the bar on Saturday. He could not have known if Mr. Kamanos was in that bar drinking on Saturday if he himself was not there.
Objection sustained.
On May 14th, what time did Mr. Kamanos pick you up with his machine?
It was about 9 o'clock, I think.
Are you sure?
It could have been 10, I'm not sure.
And you stopped at a saloon? How long were you at this saloon?
About half an hour.
How many drinks did you have in there?
We drank 1 whiskey and 1 beer.
Okay, you go back in the machine and drove to Castle Shannon. And when you got in this machine, T-Dog told you not to talk?
No, sir, in the bar. He told us not to talk about anything when we got back in the machine.
And you say you don't know where you were going when you got back in the machine?
No, sir, not until we got out of the machine and began walking. And Mike said we were going to rob the bank.
Did you see Nick Kamanos on Friday, Saturday, or Sunday before the bank robbery?
Objection, Your Honor. That question has already been answered.
I withdraw the question. No further questions, Your Honor.
I call Nick Kamanos to the witness stand. What is your name?
Nick Krenaros.
Did you ever go by any other name than Nick Kamanos?
At no time.
Where were you born?
In Russia.
When did you first come to the United States?
In 1907.
Where do you work?
The cement works in Universal.
For how long?
About 5 years now.
5 years since you last came back from Europe, right?
Yeah. Yes, I went to Europe 5 years ago.
And you stayed in Europe for how long?
About a year.
And when you came back, where did you work?
The same place. I didn't work anywhere else in America except the one place steady.
You are the owner of an automobile.
Yes, sir. A small automobile.
Do you remember being in Castle Shannon on Monday, May 14th?
Yes, sir.
What arrangements, if any, were made for that trip by you on May 14th?
On Friday, 3 men came to the shanty to me and asked me to take them to the mine. They wanted to get a job.
Did you know these men?
2 men I knew, but 1 I didn't know.
The man you didn't know, had you ever met him before?
I had not.
Tell the court what this man said, the man you had never met before.
He says, Will you take us to a mine? 4 of us like to go to the mine to obtain work.
Did he say why he wanted to go to this mine in an automobile?
He said there are no tracks to the mine, no streetcar. I asked him, when am I to take you all? He said, Monday. I says, all right, I will take you. If you pay me, I will take you.
And what was said by this man, whom you had never before seen yourself? What was said there?
He said, how much did you want? I said, $7. He said, all right, when you come, I will pay you $7. I said, no, I will not go that way until you pay me now. I said, pay me half. Well, he says, rather than pay you half, I will pay it all. And he paid me.
And you met him on Monday?
It's about 11. I stopped at the bridge and he came to me. He says, we will go. And I says, well, we will go then. Then we got in the front. I asked him, where's the others? He says, we will meet them, just go. I drove up the street and some of the 3 men were standing there in the street. He said, stop. These are the others.
Did you know any of the 3 men who got in the car?
Oh no, none of them.
Where did you go?
Where the man in the seat next to me told me to go.
You mean the boss, Mikhail Titov?
Oh, I didn't know who he was. I don't know if he was the boss. He was the man who paid me. We drove for about 10 minutes and he said stop. And we stopped. And he got out and went into a saloon.
Did you join him? Did you go into the saloon?
No, I stayed with the machine.
Did you know where you were?
No, I did not. I just drove where the man who paid me told me to drive.
Had you ever been to the south side before?
No, never before.
How long were they in the saloon?
Oh, I can't say. Possibly half an hour. I don't really know.
What happened when they came back out?
They all got back in. The guy who paid me sat next to me. He says, drive. I tell you where.
Did anyone say anything to you other than the man sitting next to you?
No. No one spoke. Only the man who paid me. After a while, maybe about 10 minutes, we came to some sort of town. Told me to turn onto a macadam road. He says, stop here. We're going to go to the back.
What did he mean by go back?
Objection.
Well, what did he say that would explain it?
He says, the man who paid me, stop. Let us out. We're going to the back.
Did you see where they went?
They walked away from the machine behind me. They went around the corner. I no longer saw them.
What did you do?
I stayed with the machine. I rested. I fell asleep.
From the time these men got in the automobile until they got out, did you see any revolvers?
I did not.
Did you have any idea that they intended to rob a bank?
Objection calls for conjecture.
Did you hear them say they intended to rob a bank?
No. The only man who ever spoke was the man who hired me. He just gave me the directions where to go.
Did they tell you at any time the purpose for being there in Castle Shannon?
Other than the man who hired me saying they were going to the mines for work, that's all I know.
When they got out of your machine at this place, Castle Shannon, what did they say to you?
Objection, repetition. The witness has already answered this question.
Did you shut down your engine or keep your engine going?
Oh, I stopped it.
Did you leave your machine at any time?
No. I leaned over in the front and was partly lying down, and I remained in that position.
You say you fell asleep. Were you awakened by anything?
Well, I heard loud noises. It sounded like shooting somewhere. I couldn't see anything, so I lay back down. After a few minutes, I looked up and saw 2 men running towards me.
And they were 2 of the men you had taken out there?
Yes, sir. The man who paid me to take them out there and another man.
What were they doing when they were running towards the machine?
They were running and they were shooting.
What or whom were they shooting at?
Oh, I can't say at whom or what they were shooting.
When they got to your machine, what did they say?
I says, what is this? And they answered me, why, they have a fight there. I said, where's the others? He said, the man who paid me. It is those who started the fight, caused the fight. He said, starts up the machine.
What happened then?
I started up the machine.
Where do you go?
Oh, I don't know. I just drove them where he told me to. The man who paid me said $7.
What happened next?
They told me to stop. They told me they were going to the mine.
Did you take them to the mine?
I did not. They says, the way you're driving this machine, we would sooner walk.
Did you see where they went?
No, they just started out walking away.
You say they got out and said, this is the place to the mine?
Objection, that's not what he said. He said that the way he was driving the car, they would rather walk.
How long after these 2 men left the machine at the place they said was the mine before you were arrested?
Objection, counsel's not only leading the witness, but putting words in the witness's mouth that he did not utter, and I object to the form of the question. They did not at any time say this was the place of the mine, according to this witness.
That is in my question.
But the witness at no time said that they told him this was the place of the mine. He said they told him the way he was driving they'd rather get out, that they would rather walk.
He also said they told him this was the mine.
If counsel will not leave the witness and ask simple questions, what they said when they got out of the car, I will not object.
Would the clerk read back the testimony?
Question, and what did they tell you then? That this was the mine? Answer, yes, sir. I told them that I will bring them to this place. But they said, the way you are driving this machine, we would rather walk.
Objection overruled.
How long after these men left the machine before you were arrested?
Oh, I couldn't say positively. I didn't watch the time, maybe 10 to 15 minutes.
Tell us what happened when you were stopped.
I was driving, and another machine was in the rear, and gave me the signal. Loads the horn for me to get on the side, and I did. I gave them the way, since they passed me for about 50 yards, and they stopped. As I approached them, they shouted for me to stop. 3 men came out of the machine with revolvers. They told me to get out of the machine and asked me where I was going. I says, I was going to Pittsburgh. When they came out of the machines, they grabbed me and they began to search my pockets.
Did you have a weapon?
No.
What else happened?
They asked me, has you the money? I told them, I don't have no money. I just had $10. And then they took that.
Who or what did you think these men were?
Objection calls for conjecture.
Did they say who they were?
No, sir.
Did they tell you why they were chasing you or arresting you?
No, sir.
Do you know where they took you?
They took me to some house. There were a lot of people there.
Were you beaten there?
Mr. Timanos, excuse me. I withdraw the comment.
Your Honor, am I preclude that I will not be able to show how my client was beaten, both by those in the house and the detectives while in the courthouse?
That has no bearing on the testimony.
But it does, Your Honor. My client was beaten so badly by the detectives that he cannot remember anything he said to them.
Objection sustained. Proceed, Mr. Craner.
No further questions, Your Honor.
Did you at any time, Mr. Timanos, go under an assumed name?
No, sir.
Did you apply for a license for your machine?
Yes, sir.
May I approach the witness, Your Honor?
Yes, sir.
I'll show you exhibit number 27 and ask you if that is your signature.
It is.
Did you have insurance for your machine?
I did.
I'll show you exhibit number 28. Is that your signature?
It is.
Did you at any time have your automobile repaired at a garage?
I did. Earlier this year, I had tires replaced.
I'll show you exhibit number 29. Is that your statement from the garage?
It is.
Mr. Kamanos, do you recognize this man? Detective Brasky, please, will you stand? Do you recognize this man? Did this man show you exhibit 30, a picture of Mikhail Titov?
Objection. This is objected to, unless it's permitted for me to show under what circumstances this man was held in the county detective's office. What duress, coercion, force, and personal violence were used to get these answers.
You can do that, of course.
Did he show you that picture?
Yes, he did.
Did you not tell Detective Cochran that Mikhail Titov was the mastermind behind the bank robbery?
Well, I don't believe so. They would hit me whenever and I didn't give them the answer that they wanted.
Would Tony Ramonko please stand? Did you not tell Tony Ramonko on the day following the arrest in this courthouse that you knew Mikhail Titov?
No, I couldn't positively say, sir. I can't say that they did. They beat me up so badly that my blood was streaming for a month from me. For a month, I was spitting blood. I wasn't even able to hear.
They beat you up out at Castle Shannon when you were brought in?
Well, they beat me a little here, they beat me a little there, but there they did finish me.
When you were brought back to Castle Shannon, there was quite a crowd of people trying to take you, was there not?
Objection. Immaterial and irrelevant.
What is the purpose of that, Mr. Rowan?
Well, he introduced this matter of his being beaten up, and I may want to investigate it a little further.
I think we better confine the testimony to the issue that is before the jury.
I'm well pleased with that ruling. I will withdraw the question. Were you ever in Castle Shannon before?
I had never been there.
Isn't it a fact that you were in Castle Shannon a week before this robbery between 12 and 1 o'clock and stood at the corner of the Oddfellows Hall leaning against the building for some little time, at least 15 minutes?
I was not in any other place except Pittsburgh and Homestead.
Then, Mr. Opperman, will you please stand? Mr. Opperman, there we are. Calling your attention to Mr. Opperman, who's standing in the courtroom and who testified earlier to seeing you standing in front of Oddfellows Hall a week before the robbery. Did you not see this man? I want this answered yes or no.
No, sir.
Thank you. Mr. Rawa, please stand up. Did you not talk to Mr. Rawa in the courthouse about the bank having been robbed at Castle Shannon?
Yes, sir.
And did you not tell Mr. Rawa that the story you told here in the witness stand about your connection with his men who committed the robbery?
Objected to as improper and incompetent. What he may have told them there, or whether he told the story here, is not a fair question.
Mr. Rowand, you should ask exactly what he did say if you intend to contradict him, and I assume that is the purpose of your question.
Very well. What did you tell Mr. Rawa?
He asked me if I was there in that place. I says, what place? I don't know what place you mean.
Is that all that was said?
Then he went away.
Is that all you said to Mr. Rawa?
Yes, sir.
Permission,
Nothing further.
permission to redirect, Your Honor?
Allowed.
You say that there were about 50 people in the room of the house at Castle Shannon.
Yes, sir. And maybe more. They'll just look at me and someone struck me.
Do you know the man that hit you, or have you seen him in this case?
Yes, sir.
Objection, irrelevant.
What is the purpose of the question?
Your Honor, if that man that struck him was a witness in this case, he might explain the witness's attitude in this matter.
Struck him where?
The man who struck him repeatedly in the face in the house where about 50 people stood around. One man stepped forward, struck Mr. Kamanis repeatedly. I want to see if he was a witness in this case.
Very well, proceed.
Have you seen the man who struck you in this house testifying in this case?
Yes, he was here yesterday.
Mr. Yost, you can stand up. Was this the man?
That man pulled me by the hair and then he struck me in the face.
You are talking about the man who testified yesterday that you shot him in the leg, correct?
Objection. Mr. Kramer's putting words in the witness's mouth.
Sustained.
You may sit down, Mr. Yost. Mr. Brasky, stand up. Mr. Brasky?
He's apparently left the courtroom.
How many times did Mr. Brasky strike you?
Objection, irrelevant.
I will allow it, Mr. Rowan.
How many times did he strike you?
Steady. He was hitting me, I was leaning over, and he just kept hitting me across the face. First slapping me, then punching me in the jaw.
Stand up, Mr. Cochran. Yes, sir. Did this man hit you?
I'm not positively sure.
Did he stop the other man from hitting you?
I don't know. It was...
What time was this?
Oh, I'm not sure. It was after midnight. I heard the clock strike 12, maybe 1 a.m., maybe later.
Did they take you to jail?
Oh, they did, but they brought me back.
You may sit down, sir. How long before they brought you back?
A couple of hours, I guess. The sun hadn't come up when they brought me back in the room. I couldn't tell because the window in the room, it was still dark out.
Do you have a license, Mr. Commands?
Yes, sir.
Is permission to approach the witness, sir?
Permitted.
Is this your license application?
Yes, sir.
What name is on it?
Nick Kravanos.
Do you have insurance for your machine?
Yes, sir.
Is this your insurance statement?
Yes, sir, it is.
What name is on it?
Nick Kravanos.
Why Kravanos?
That is how my name is spelled in Russian.
Your Honor, the defense vests.
Prosecution may present its closing argument.
Gentlemen of the jury, on May 14, 1917, the defendant, Nick Kamanos, drove his automobile to the village of Castle Shannon, and with him were 4 other men who have been identified as Mike Tikoff, Stan Larkins, John Tush, and Raska Garrison. These 4 men left the automobile and went to the First National Bank of Castle Shannon. Some of them were armed with revolvers, and they went there for the purpose of robbing the bank. The men who went into the bank shot the cashier, Daniel McLean, and the assistant cashier, Frank Irby, killing them both. The defendant is on trial for the murder of Frank Irby. The four men ran up from the bank, who were heading toward the golf course, and the others were heading back to the automobile, where Cananas was instructed to start the car because there was a fight back there. If the defendant was with the men in the bank, he's guilty. Squire Beltsuper, the town's justice of the peace, says Cananas was in the bank. We have testimony from witnesses who saw no one with a getaway vehicle, meaning that Mr. Cananas has ample time to go to the bank and get back to the vehicle before these two men came up the street with a crowd following. The defendant claims he was not at the bank. If he was there, as I said, he's guilty. If it's the fact that he was not in the bank, it doesn't require an acquittal. If it's the fact that he was not in the bank, you have this situation. The defendant came to Castle Shannon conveying a party of armed men who came to rob the bank. He waited for them, and when they came running, firing at their pursuers, with the pursuers firing back, he helped these two men escape. When a man is with a gang of robbers and flees with them, the natural conclusion is that he was a participant or a confederate. Whether you draw that conclusion or not is for you to decide. The Commonwealth has shown through testimony that the defendant knew some of these men before. He was with one of them at a saloon in Fairhaven the Friday before the robbery, and he was seen in Castle Shannon a week before the robbery watching the bank during the lunch hour, which was the time at which the robbery actually occurred the following week. We have testimony from Nicholas Yost, who says he was shot in the leg by a bullet fired from the automobile, specifically from the side where the driver was sitting. Mr. Camano says he did not fire on the crowd. However, if he did fire on the crowd and did hit Mr. Yost, well, that's a significant thing. It speaks to his knowledge of what was taking place, a bank robbery. The Commonwealth asks you to find that he had knowledge, aided, and abetted the escape, and was party to the robbery. Where a crime is committed and a man flees with some who were shown or proved to the satisfaction of the jury to have committed the crime, it is for the jury to say whether that flight is an admission, confession, or knowledge of the crime. And this is guilty knowledge. If the defendant was at the bank, he's guilty. If the defendant knew the purpose of the four men, he is guilty. If the defendant took them away, this is aiding and abetting, and he is guilty. Thank you.
Mr. Kramer, defense closing?
Nick Jimenez was hired days before the Castle Shannon bank robbery as a chauffeur by Mikhail Titov, who said he and some friends needed a ride to a Southside mine to seek work. Kamanos did not know Titov. However, Titov knew of Kamanos, or more important, of his new vehicle, a touring vehicle capable of holding 5 people. You see, Nick's landlord was married to Titov's sister. Nick refused to drive Titov anywhere unless he was paid by banks. Titov gave him $7 to drive him and his friends to the South Side. Give him a stop on the way to the saloon. Nick probably assumed he was a designated driver for the 4 men, who seemed more bent on getting hammered than finding employment. Now, the cop claims that Nick Jimenez was in the bank for the robbery, knew what the 4 other men planned, and aided and abetted the flight of 2 of them from Castle Shannon. Take this a step at a time. First, Jimenez did not know any of these men. If he did, why would he charge them $7 for renting his machine? And if he knew they wanted to rob a bank, why charge $7? He would obviously be making much more than that in a bank heist. He demanded payment in advance because he didn't know Titov and didn't trust him to pay him if he didn't get the money up front. The man has testified that he would remain in the machine the entire time, occasionally napping in the car. Dr. Brown's wife testified she saw him standing near the car, and it looked like he was checking the tire, but she didn't see him all the time. Well, how could she? She was viewing him from her home. She never came down to investigate. When Kamanos napped behind the wheel, he would have been at the farthest point from her sight line. And we've had several witnesses, including the defendant, who testified the vehicle's top was up. Furthermore, Dr. Brown's wife testified she saw a man standing by the car. She did not attempt in her testimony to say that man was Jimenez. The Stanley robbery says he's not sure he saw Commandus in the bank. But Bravo's testimony comes into question. First, he thought there were 6 men in the bank, or maybe it was 5. He admits he was scared and not sure. Second, Mr. Bravo's testimony changes significantly from what he said in Nick's first trial, where he was acquitted of the murder of Daniel McLean. In that trial, he says he can't say whether Commandus was in the bank or not. Now he can. Gentlemen of the jury, Mr. Bravo's testimony has differed every time he has been called in to testify. In the coroner's inquest, in Sam Barker's trial, and in the trial of Commandus for the murder of Daniel McLean, for which Mr. Commandus was acquitted. We also have the testimony of George Belzer, the Justice of the Peace for Castle Shannon, who testified he saw the witness come out of the bank. In fact, it is the first one out of the bank. Of course, when Mr. Belzer opened fire on the bank robbers, it was with an unloaded shotgun. After 3 trials, Mr. Belzer says it was getting a bit warm out there and he took shelter behind some shrubberies. In the course of the robbery passing Belzer, he was cold-cocked with a bag of coins which resulted in disorienting him and breaking his nose. Belzer admits he was fearful for his life, and fear of death can often cloud one's judgment when it comes to details. In fact, on one detail, Belzer's judgment has already been questioned. During the coroner's inquest, Belzer testified the first man out of the bank was Sam Barkins, the man who supposedly shot himself in the woods. Furthermore, we have the testimony of H.J. Brown, a businessman, who was one of the half-dozen or so he had chased in the funeral director's service. Brown says when he approached Commandus' machine, Commandus say, quote, "Me got no money, me got nothing," unquote. Now the comment has twisted this around, meaning Mr. Commandus was referring to money from the bank robbery. Put yourself in Nick's shoes, please. Your car has just been run off the road by another vehicle. More than a half-dozen men disembark with the first degree pointing pistols to you as you approach. Would not your first instinct be to think that you were being robbed? Then the plea, "Me got no money," is one for fear of one's life. Don't shoot me. I don't have anything of value on me. And he didn't. No money, no weapon, nothing. And we have testimony that they searched his pockets and his vehicle. As for knowing what his clients, who had hired him to look for work in the mines, were up to, Commandus testified that when the 2 men approached, they told him to get going. They started a fight back there. And Commandus started his vehicle and drove off. The 2 men continued their banter about the 2 other men starting the fight, while T-Top told Nick where to drive. Eventually, they asked him to pull over and got out saying, quote, "The way you drive, we'd rather walk," unquote. During this time, Commandus saw no money bags and no weapons. In rebuttal, Mr. Charles Berger, a bartender, testified that Commandus was drinking in the bar on Saturday before the robbery with 2 men, one of which he identified as Sam Barkins. Now, Barkins has testified that he didn't know Commandus, was not drinking with him on Saturday, and Barkins was the first man who bolted out of the bank after the robbery. How was the Berger came to recognize the men Commandus was drinking with? From a photograph in the newspaper the day after the robbery. And when did Mr. Berger deem this information important? 5 months after the robbery, when he finally told investigators. Gentlemen of the jury, do your duty. And your duty is to acquit Nick Commandus, as did the jury that preceded you in the first case. Thank you.
Gentlemen of the jury, the burden of proof in this case, and in any case, is on the Commonwealth to prove the guilt of the defendant beyond a reasonable doubt. The burden of proof is on the Commonwealth to prove that Frank Irby was killed. In this case, there was no testimony given to suggest that that is not a fact, that Frank Irby was killed. That Mr. Irby was killed during the commission of a robbery has not been disputed by the defense. Therefore, the burden is on the Commonwealth to show either one of 2 essential things that I wish now to call to your attention. The presence of the defendant in the bank at the commission of the robbery and murder, and the Commonwealth must satisfy you that beyond a reasonable doubt before you would be justified in finding that to be a fact. The burden is on the Commonwealth to satisfy that you beyond a reasonable doubt that the defendant had knowledge of the purpose of these men. That is, to sum up, the burden is on the Commonwealth to satisfy you beyond a reasonable doubt that the defendant is guilty. A reasonable doubt, as you well know, gentlemen, is not merely any doubt. It is not a mere hesitation, neither is it any feeling of reluctance that you might have to convict it. It is the duty of the jury to pause and weigh the testimony and to come to their conclusion deliberately. A reasonable doubt means that if you have, in your minds, after a careful consideration of the case, an honest, substantial doubt arising out of all that evidence, which would leave your minds in grave uncertainty so that you can consciously feel that you could not convict the defendant, it will be your duty to find him not guilty. But if the testimony is satisfactory, if it is such as you would cause you to act in important matters of your own life, then it is your duty, and you would not have a reasonable doubt, and it would be your duty to convict. It has appeared, gentlemen, in this case, in your hearing, that there was another trial. Witnesses have been asked questions whether they testified on a former trial. That was not a trial of this defendant for the murder of Frank Irby. I have nothing more to say to that than this, that I do not know, and I am satisfied that you do not know anything about that case. The verdict in another case should have absolutely no influence upon the jury. The responsibility for this decision is up to you. If this defendant is guilty, he is guilty of the most serious offense, far more serious than the ordinary murder. If he is guilty, he was one of a party who in broad daylight cruelly and wickedly shot and killed in perpetration of a robbery. Under the law, that is first-degree murder, and you have no escape from that proposition. If you find this defendant guilty, you can find him guilty of nothing else but murder in the first degree. The second point I wish to affirm. If the jury believes that the defendant was simply assisting two men in escaping from what he believed to be a fight, then their verdict must be not guilty. This affirmed, gentlemen, if your finding is that he was not in the bank and did not know the guilty purpose of the men who went to the bank, that is all, gentlemen. Do your duty.
After one day, the jury came back to ask the judge to dismiss them because they couldn't agree on the verdict. Judge McFarland told them to go back into the jury room and continue their deliberations. The second day, the jury returned with a verdict of guilty as charged at the mercy of the court. Judge McFarland rejected that verdict too, informing the jury that there were only two verdicts permitted in this case, not guilty or guilty of first-degree murder. He ordered the jury back into deliberation. On the fifth day of deliberation, the jury returned with a verdict. Would the foreman please bring the verdict?
Has the jury reached a verdict? Will the bailiff please deliver the verdict to the court? Will the clerk please read the verdict? Will the defendant please rise?
We, the jury, find the defendant guilty of murder in the first degree. Kramer then eventually appealed to the Pennsylvania Supreme Court, contending Kamanos had been denied his constitutional rights under the double jeopardy clause. While awaiting his appeal in jail, Kamanos contracted the Spanish flu during the epidemic of 1919 and died. How serious was that flu epidemic? So serious that the Stanley Cup was halted 5 games into the finals. The only other time besides the lockout shortened season of 2004 and 5 that the Stanley Cup had been canceled. In all, more than 100 million people died of the flu, nearly 5% of the world's population. The case of Nick Kamanos could have been history-making because it was 50 years later that the U.S. Supreme Court heard the first double jeopardy case in our country's history.
The sentence of the law is that you, Nick Camanos, for the murder in the first degree of Frank Irby, whereof you stand convicted, be taken hence to the jail of Allegheny County, whence you came, and you be taken thence, as required by law, to the Western Penitentiary in Center County, Pennsylvania, and during the week fixed by the Governor in the Commonwealth of Pennsylvania in his warrant, that then and there in the building, and in the manner and mode provided by law, a current of electricity shall be caused to pass through your body and continued until you are dead. And may God in his infinite goodness have mercy on your soul.